7 years after my last visit, and I could see great change. Of course, the food is always great. The warmth is even better. The smile, the civilization, the history, always touching. And I'm very proud of the achievements this country has made and the success that it's really showing the world. Let me explore with you what I consider a path to excellence. And I think we've learned a lot of facts from Diana's very helpful opening remarks and Mr. Botman's opening remarks, as well as Professor Stormby. And I think there is a lot to learn for developing jurisdictions who want really to take first steps on the path to excellence from the Uzbek experience. What I intend to do is to go through some of the issues that I consider relevant for this path to excellence. So I will start with the status quo, what I call the winds of change in international arbitration today. Then I will address the landscape of arbitration in Uzbekistan, touching on some facts and perceptions. Because whether we like it or not, facts are facts, and that is true, but perceptions do matter as well. And then, through the safety principles, which I think define what global seats of international arbitration should be doing. And then I will conclude with what I propose as the 12 commandments on repositioning Uzbekistan as a go-to seat for international arbitration. For Central Asia, but more importantly, beyond. So not just regional, international. So the changes. I think today we can safely say that the world is more divided than ever for generations. Not necessarily a positive development, but certainly an interesting one. There is a proliferation of seats of arbitration, increase in the number of arbitral institutions. In fact, every country, I must say, every city wants to have more than an arbitral institution. And of course, the competition is high, and there are even newcomers. And when I refer to the newcomers, these are not the traditional institutions of arbitration, but the ones really powered by artificial intelligence. So they do not have the requisite expertise in dispute resolution, but they have the expertise and the technical know-how in the use of AI. And Professor Stormby has actually alluded to the role of AI in that sense. Then the nexus, what I call, given the division and the fracture we see in the international legal order, we see that there is a degree of tension between the global set of principles, the regional, and the local. One example is looking at what the European Union approach to certain aspects of dispute resolution compared to the international view of dispute resolution in line with international treaties and instruments. There is a tension, there is a friction, there is a degree of inconsistency, and arbitral tribunals are always grappling to resolve these issues. In addition to that, the local aspect. And we've heard that Uzbek courts have not set aside any arbitral award on public policy grounds. Now that is a very positive development, absolutely, and a clean sheet, I have to say. But I actually have to tell you this with all my conscience. There are arbitral awards that deserve to be set aside. And it is not a bad thing when there is a situation like that. And I say this because when French courts or English courts refuse enforcement or set aside, or even Swiss courts, this comes across as something good, innovative, because they have always exercised caution when it comes to arbitral awards. But the moment any developing jurisdiction sets aside an arbitral award, it is a negative development. Now, this double standard should end. The judgment of whether an award ought to be set aside or not ought to be a merits objective-based assessment and not on the basis of who or which court is setting aside. I say that with a clean conscience to know that yes, we advocate for arbitration, but we advocate for good, credible arbitral proceedings that are protected with integrity in that sense. To the extent any of those pillars fail, then arbitral awards become under scrutiny, which takes me to the other point, that is international arbitration today is increasingly becoming under scrutiny. Investment arbitration, and we see the new developments as well within the UNCTAD Working Group 3 about investment arbitration and the need to establish a standing mechanism and the challenges and criticisms always to investment arbitration, and reforms are well underway. There are, of course, challenges and need for reforms, but I think that international arbitration will continue to coexist with other non-ad hoc processes, including standing mechanisms in a way. Then we come to the disruptors, which are destined to change the dispute resolution landscape worldwide, especially in arbitration. There is a rise in international commercial courts because arbitration, in certain instances, has failed sometimes to deliver on time and cost, have become quite rigid. In fact, in some instances, it has become very difficult for those who are not financially capable to engage in arbitral proceedings. And so, international commercial courts, non-localized, permanent establishments have been proliferating across the globe in many countries to try and offer a possible alternative. Now, of course, this did not bring an end to international arbitration, nor will it do so, but it will coexist as one of the disruptors. And it will become a race to excellence as to whether international arbitration and arbitral tribunals will be able to deliver the quality of justice that disputing parties aspire to achieve based on trust, confidence, and legitimacy of the process. Then what I call AIDR, which is artificial intelligence dispute resolution. The world has moved from ADR to ODR to now AIDR. And whether we like it or not, and I think many of us still hope that AI will continue to be used as a tool to support human judgment, but whether we like it or not, AI is destined to also substitute human judgment. It's going to coexist when we arrive at a stage where there is artificial general intelligence. You will be able to get an AI-generated award at a fraction of the costs, fraction of the time, and you will also have the option to get a handmade, human-made award, should you wish to do so. Think of it this way. When you go and buy a product in the market, there are handmade, expensive products, and there are massively produced or machine-produced products that are also available. So there will be a situation where AI will coexist as a substitute with human intelligence, and there will be hybrid forms, but that is perhaps for another day to discuss. But it is indeed one of the major disruptors. And people are focused on one aspect, which is substituting arbitrators by AI. But let me tell you this and perhaps break the news. It is not just arbitrators. Lawyers, experts, and all stakeholders in the arbitral process are susceptible to that challenge and that potential change that will disrupt. And then the geopolitical tensions that we see in the world, which I think is something very relevant to Uzbekistan, which, as I understand, is not closely linked to volatile situations happening in other parts of the world. And that is a blessing, because then you can offer a safe harbor for proceedings in that sense. Trade wars, sanctions is one of the big challenges in the world of international arbitration today. And the sanction wars or cross-sanctioning is, again, one of the main areas that arbitrators are grappling with and dealing with almost in a very high percentage of cases involving parties from a fair number of jurisdictions. Economic crises are indeed looming, but amidst all this, there is hope. Sometimes when it gets really gloomy, really dark, and hope is lost, there is light at the end of the tunnel. And I'm still hopeful that humanity will see a degree of sanity in coming together to overcome the situations that we see today and the legal fracture that the world is experiencing. Now that takes me to some of the facts and perceptions in Uzbekistan quite quickly there. So there is a checklist. If you're investing or doing business in a country, there is a checklist. And I think Uzbekistan ticks all the boxes on the checklist. Join the Muir Convention, exit Convention. It is a model law jurisdiction. I love the UNCTAD model law with the 2021 International Arbitration Law of Uzbekistan. There is a number of CIS treaties, which Uzbekistan is a party. There is a vibrant community of talented practitioners, and I have met a number of them, and I feel that this country really has a lot to offer in terms of the legal community in Central Asia and beyond. It is a desirable destination for those who know. As I mentioned, when you come to Uzbekistan, I was very pleased to hear Diana saying it ranks as the safest country in the world. Let me tell you, you may go today to certain parts of Europe and it is not safe. I was sitting with colleagues in an arbitration and we were considering whether we should have a hearing in an African jurisdiction, and colleagues said, oh, but it's not safe. I told them, gentlemen, because they were two gentlemen, it is safer than where we are in Europe. So we need to change these misconceptions and embrace the idea that the world is changing and recalibrating in that sense. Of course, it is established as a regional hub, and I think the cross-institutional framework with HKIAC is a very good initiative, and I was very pleased to know that there is a precedent now of having an arbitration clause cross-institutional. And it is a testament to something very interesting. Institutions can compete, but they should also collaborate and cooperate. And I think that is a key point that many people miss. Now, on a more granular level, I think these are some of the highlights of the international arbitration law of Uzbekistan that I find very interesting, including the idea of concluding arbitration agreements by electronic means, the default power of arbitral tribunals to countermeasure and relief, which are all in the UNCTAD model law. But I think two highlights merit mention. One, immunity of arbitrators. People, and I face many people in the younger generation saying, we want to work in arbitration and become arbitrators. And there's always the question of, I want to become an international arbitrator. Okay, why don't you want to become an international counsel? Why don't you become something as well in the arbitration field, but not necessarily arbitrators? There are many areas. But immunity of arbitrators is relevant because arbitrators, in some instances, are getting sued as part of a tactic. They are subject to certain injunctions, which does not enable them to render the justice expected without fear of prosecution. And so here, Uzbekistan provides a very clear provision, Article 6, save for intentional wrongdoing, there is an immunity of arbitrators. And I think that is a key provision. Another one is the importance of looking at international arbitration from the perspective of internationalism. And so you apply that to the arbitration law of Uzbekistan, which helps because then you have the cloud, which is the UNCTAD model law cases across the globe, that will enable the Austrian judiciary as well to align with international best practices and see the precedents that could be of value irrespective of the legal system that is applicable. In 2022, I understand there's been an economic procedural reform for the code that enabled economic courts to provide assistance to international arbitration. And I say that because you can have the perfect legal text, you can have a perfect house or a venue, but if the judiciary does not buy into international arbitration and does not support it, it becomes hopeless. And that is why I say the judiciary is the most important and quintessential ingredient to a successful seat of arbitration. You may not have a good law, but if you have a good judiciary, that will do the trick. And I think in 2023, precisely in November, it was interesting because the plenum of the Supreme Court of Uzbekistan adopted a resolution that settles the score regarding the application of the New York Convention, which again is another landmark thing because predictability and certainty are key. So let me then take you to perceptions and action plan before we conclude with the commandments. So the global perceptions. We can say that we're doing great and wherever we are, and Uzbekistan is doing great. But if someone is not following the news in Uzbekistan or Central Asia, someone perhaps in the US or somewhere else who does not know what Uzbekistan is, I can tell you I've met people in the US who do not know where Egypt is, which to me was a bit surprising. So what are these perceptions? Some of those businesses are not familiar with the region. So their first port of call would either be a word of mouth or friends, or counsel who may be familiar, or today, consulting the available AI tools. And then what can be done? So what I did is that I did a test. I looked at effectively, if you enter a question at OpenAI Chat 5.0, that's the latest AI model available with paid subscription. So it's not the free one either. So it's the top of the line, state of the art, the best that can offer. And let me tell you today, all the AI is available. And I do that, it's part of what I test on a daily basis, given the interest in artificial intelligence. There hasn't been a single day that I pose a question to any AI, and I have a host of them, and I get either a complete or an incorrect answer. There is always incompleteness and incorrect answers. And if you don't know your stuff, you're going to fall into the trap of getting wrong information. So today, I can tell you safely, there is 100% chance that you will always, no matter what you ask and how precise your question is, you either get an incomplete or an incorrect answer in part. So you need to cross-check. So let's see what AI has to say. And this is quoting verbatim from it. So I asked it, and it's produced it. Is Uzbekistan a good seat for international arbitration? And one has to wonder, after all the great things that are being done on the ground, what more can you, as OpenAI, or even DeepSeek, or Perplexity, or whatever AI, no matter what the name, have to say other than to say, oh, they're great, but look at this. Perceptions are improving, which is interesting. But Uzbekistan is not yet widely viewed as a top-tier global seat for international arbitration. Recent reforms and institution building have strengthened its case, but concerns about enforcement, experience, political and regulatory risk still tamper international confidence. Now, if you are a business person, not familiar with the jurisdiction of the region, you get that, it becomes a concern. There is no clarity on what type of enforcement problems experience. There is always room for improvement. What risk are you highlighting in that sense? And then using the word confidence. And then after the analysis, the bottom line, Uzbekistan is moving in the right direction. Well, thank you very much. And has the ingredients to go as a regional international arbitration seat. And I had to wonder, look at the question, is Uzbekistan a good seat for international arbitration? And the answer is, well, your hope is to become a regional seat. Why do you confine the potential of a country to a regional hub? If you aim and you aspire, aim big. And so, I see no reason in including the word regional, but again, because the perception is you will be as good as a regional hub. My advice, don't take that. Just aim to become an international seat. And we have examples in Asia which have effectively recalibrated and knocked off traditional seats in international arbitration. And then it adds, you need a sustained track record of consistent pro-arbitration judicial practice, more high quality institutional experience, continued transparency, and rule of law signals. Now, if you intend to probe any of those and take it deep with the AI, you will not get concrete answers. They will tell you there isn't sufficient data available. And then one has to wonder, if there are no sufficient data available, why the answer that gives a degree of concern? So this takes me to the idea of what would make Uzbekistan a go-to seat for international arbitration. Then I conclude with these 12 commandments. Uzbekistan has got potential and momentum. The safe seat principles. Now, look at the international seat. Traditionally, people would say, when you do international arbitration, London, Paris, and Geneva. New York here and there. New York is a bit suffering now because of the accessibility issue. But look, Hong Kong and Singapore have actually told the big guys usually, please step aside. And Singapore has actually knocked those off in a way. And Hong Kong is also doing great in that sense. So, there isn't any impossibility for Uzbekistan or any other country taking a right path to excellence, not to aspire to become one of the global seats internationally. If we look at the safe seat principles of the Chartered Institute of Arbitrators, the law, you have a modern law that is aligned with international best practices. The judiciary, we have seen that there is elements of independence, competence and expertise in international arbitration, and a degree of efficiency, at least a good shield, especially, and to me, let me tell you this, the mark that people look at when it comes to judiciary is whether there is an involvement of a state or a state-owned entity, how the judiciary acts. And I think the example of the Bukhari water utility is a clear example of how independence matters most. In addition to that, legal expertise. Parties seeking representation with qualified Uzbek counsel, or even counsel who practice arbitration, and even if they're not Uzbek in a way, and have capabilities. Now, of course, English language, whether we like it or not, dominates. So the language of international arbitration is English, and Spanish, French, and to a degree Italian, and now Mandarin as well is rising. So you see, and the new generation are effectively becoming more and more multilingual. In addition to that, education, which is key. I'm in the presence of the rector of the Tashkent University, and education is extremely important. One of the highlights for Singapore as a jurisdiction is that the National University of Singapore has become one of the top 10 universities worldwide. You educate people, you effectively prepare them to be in the pipeline to become leaders in dispute resolution in any area of law. In addition to that, you have right of representation. I'm going to come to that, which means there are no barriers to non-legal counsel and non-nationals to actually practice international arbitration. Safety, you rank number 1. What more can be done? Access. Visa, if for countries, I think people need to rethink visa programs to the extent that helps. You need, of course, facilities with top-notch, state-of-the-art facilities to host hearings, which requires, again, good facilities and internet accessibility. Ethics and integrity is number 8. Enforceability, again, is important. And then finally, immunity, which ticks the box in the international arbitration law. So pretty much, Uzbekistan is there when it comes to the safety principles. So then, what are my 12 commandments? I will end there. Proposals, think of them, of how Uzbekistan can position itself globally, not just regionally, to become a go-to seat. And I'm telling people, when I visited Uzbekistan 7 years ago, and I asked, arbitrators, have you visited Uzbekistan? And I do that as well with Rwanda, because many people have not been to Rwanda in Africa. I tell them, one, both are very safe, very nice, you will enjoy your time there. And when people go there, they realize. So I think it is extremely important to showcase the beauty of a country like Uzbekistan. One, judicial practice directives for lower courts, explaining the pro-arbitration statutory interpretation. It is more often than not that Supreme Courts have to correct the problems that lower courts have to deal with. And so if you have these guidance for lower courts from the beginning, then it makes life easier and it will reduce the case backlog and it will ensure predictability and certainty. Two, perhaps it is time to consider a specialized chamber or circuit in higher courts to handle arbitration matters. If you have judges trained and if you aspire to become an arbitration hub, you may consider having a dedicated chamber that deals with arbitration-related matters. That will boost confidence, predictability, certainty, and will build expertise among members of the judiciary. We don't see quite often Uzbek judgments showcased about the good judgments rendered by Uzbek courts. It is high time to translate, publish, and make those judgments with statistics available globally. Not just as an institution like what TIAC is doing, which is excellent, the Tashkent International Arbitration Center, but also the judiciary publishes that so that it's accessible to the public. And by the way, there are many judiciaries across the globe now that look at judgments of other courts. And so there is no reason to exclude Uzbekistan from the equation. Improve and expedite enforcement. As we mentioned, there is always room for improvement. Capitalize on Uzbekistan's proximity to Europe, the Middle East, and other parts of Asia. Now, I got to learn from my dear friend Judicial who's here as well, I think, who's an expert on blockchain and crypto assets, that Uzbekistan is ranking very high in this area. Now, this is something that can give a leading edge to Uzbekistan and perhaps even invite Tashkent Arbitration Center to do something like what the Asian International Arbitration Center with the I rules, do something in relation to cryptocurrency and virtual assets rules. Although I don't think rules will differ that much depending on the subject matter. But it will create a buzz, it will create attention globally. Establish cooperation and judicial dialogue programs with leading global institutions. ICCA has these programs. The Hague Academy, the ICCA, the CIArb, the PCA, they all have programs which involve judicial dialogue among judges from many jurisdictions. And I think Uzbekistan needs to participate in these dialogues. International arbitration, a little bit of conscious bias, should be a mandatory subject for undergraduate law students. I understand some of the universities here teach it, but I think it is important that it becomes a mandatory course. Continuing education and training for Uzbek practitioners to enlarge the pool of international arbitrators, counsel, and support services. A country now, which I think has a population of more than 40 million or so, deserves to have more practitioners on the world map, not just domestically or regionally. And I think the first step to convince the international community that Uzbekistan is a good seat and a place for arbitration is that you need voices, not silent voices and not silenced voices, voices who can speak with gravity, credibility, and substance. And when they speak, people listen. And I think Uzbekistan has a lot to offer from what I have seen with the good practitioners here. Increasing accessibility to Uzbekistan by adopting what I would call a visa waiver for international arbitration seated in Uzbekistan. I say that because that actually has been implemented in Rwanda. Rwanda started with a visa waiver if you come to do international arbitration. Then it proved to be successful. So they implemented it all over. So now you can go to Rwanda without visas. I realize in certain parts of the world there are security concerns. But being a very safe country, I think people can manage, and I think a visa waiver program for international arbitration would be very well received. Number 10, accentuate Uzbekistan technology and AI infrastructure build state-of-the-art facilities. Build it and they will come. If you have this strong presence in cryptocurrencies, blockchain, and technologies, build a world-class destination for a hearing venue. Not an arbitral institution, you already got the Tashkent Arbitration Center, but a hearing facility. And market Uzbekistan as an arbitration tourism destination. So far, the countries that is marketed like that is Switzerland. People go, international arbitration practitioners, when they go to a country, they spend money. Arbitrators, they stay in good hotels, council, and if it's a lovely country, they will spend money. It's going to really be a very good approach. And that is what I call arbitration tourism. Offer relocation incentives for foreign arbitration practitioners and arbitrators. And I know very well how people feel. Okay, this will threaten the national talent, and international firms are going to come in, take over. I disagree. In Egypt, I tell people, come and compete. It is always subject to the individual skills and capabilities of people. Let everyone compete and give them a fair chance in any event. But if you close your walls and doors, it's going to be an issue. If you aspire to be a global hub, this is one of really the requirements needed. I leave you with these few thoughts, but I thank you very much. I wish you a very pleasant day, and I very much look forward to learning a lot more from the coming sessions and panels. Thank you all very much.